Thank you very much. I'm just going to gallop through some recent developments in public law. Many thanks to Julien, who most of you know, who prepared the notes. The first case I wanted to look at is in relation to the joinder of a father without parental responsibility. That's the case of S, a child 23 case, where the Court of Appeal was concerned with an appeal brought by a biological father without PR against the judge's refusal of his application to be joined as a party to care proceedings in relation to his son S, who was 11 years old. The father was not named on S's birth certificate and obviously therefore didn't have parental responsibility. Further, the father was actually S's mother's uncle. And so S always believed the biological father, to be his uncle. And the mother made allegations of rape against the father, etc. And the court, the father made an application to be joined as a party, etc. Now, the case came before late Justice King, who set out the relevant law as to joinder. And essentially, as a father without parental responsibility, his application is made under Rule 12.33a, which provides that the court may at any time direct that a person or body be made a party to the proceedings. There's no guidance in the FPR or the Children Act as to the factors which the court should consider when exercising its discretion. However, the court must apply the overriding objectives in Rule 1.1. And the guiding principles was said to be as follows. The child's welfare, important but not paramount. Where a father without PR applies to be joined as a party to care proceedings, there's a presumption in favor of granting the application unless there's a justifiable reason for refusing it. No requirement for a father without PR to show an arguable case or even to have a specific application to make. And what amounts to a justifiable reason to rebut the presumption in favor of a father being joined is a matter of discretion for the judge, having considered and put all factors into balance. No requirement to consider the factors in Section 10.9 of the Children Act, which relates to the joinder of persons in relation to Section 8 orders in private law proceedings. Court must consider parties' Articles 6 and 8 rights, and presumption in favor of the father being joined should not be displaced if the concerns of the other parties, and very often it is the mother, can be properly mitigated by the court making use of the extensive toolkit now available to it in the form of its general case management powers and powers in relation to vulnerable parties. So essentially participation directions. In allowing the appeal, late Justice King said that even without PR, the father is treated under the Children's Act as the legal parent and is entitled as of right to apply for any orders in respect of his child. Further, if his child is in care, the father is entitled to reasonable contact with the child. That's under Section 34.1. She added that it's surprising that the starting and often finishing point when considering whether a father without PR should be joined as a party is the presumption in favor of his being granted party status, regardless of whether or not he's got an arguable case. While the court may make orders to restrict disclosure of documents, it is when strictly necessary, and particularly if the alternative was to deprive the natural father of the opportunity to essentially participate in the proceedings. Judge went on to hold that the trial judge had failed to assess the necessity and proportionality of the order made, and to consider what steps could be taken to mitigate any potential impact of the joinder on the mother and the child, and that there was no justifiable reason to essentially refuse the father's application. Moving on to case about removals at the interim care order stage, we look at the case of Reed J. and others, a 2023 Court of Appeal decision that reaffirmed the test for separation as set out in Re C. This was a case where the mother had long-standing difficulties with substance misuse and mental health problems. There was domestic violence. After the parents had separated, the children remained living with the mother. She was arrested for drink driving, left the children alone overnight, charged with child neglect. And as a result of that, the children were placed with the father. Now, unfortunately, after, for unknown reasons, they were returned to the mother after a few weeks. There were attempts to engage the mother with the PLO process, which were unsuccessful, and the local authority then issued proceedings, initially seeking interim supervision order. There was then an incomplete parenting assessment of the mother due to lack of engagement, and there was, however, a parenting assessment of the father, and that concluded that he had the capacity to meet the long-term needs of the children. Now, notwithstanding that, the children remained in the mother's care up until May 2023, when there was a referral made by the ambulance service about the mother's health, and the children were then placed back with the father. When the matter came before the court, the district judge urged that there should be more extensive contact between the children and the mother, including unsupervised and overnight contacts. And that shortly after, the mother started to make allegations against the father. Despite this, the father had permitted the children to stay at the mother's house over the weekend, and on that basis, the local authority sought a change in the interim care plans for removal of the children into foster care. That application had been opposed by the parents. The father in particular said that he misunderstood the effect of what the district judge had said about the mother's contact with the children. Local authority would not amend their interim care plan, and on that basis, the guardian reluctantly supported removal, and the ICO with removal was granted. When the matter went before a court of appeal, Baker LJ reiterated the principles to be applied as summarized by Peter Jackson and Reece C. And he noted that whilst latitude must be afforded when considering judgments delivered ex tempore, this judge had failed to apply the test for immediate removal. There was no reference in the judgment to the very positive evidence about the care being provided to the children by the father. There was no the evidence of the social worker was that there were no safeguarding concerns about the children whilst in his care. There was no analysis of the risks the children would suffer if removed from the father's care, as opposed to the risk they would potentially suffer if they remained with him. And the judge had essentially failed to give consideration to the least interventionist option, which is that the children remained at home. And finally, the judge was criticized for refusing to allow even a short stay of the order to enable the father to appeal to the Court of Appeal. And the Court of Appeal said that this was contrary to authority and wrong in principle. Even if the judge's view of the risks were correct, these risks could never be described as so acute as to justify denying this father the short stay. And the Court of Appeal said that courts and practitioners must follow the course identified by Peter Jackson in Re N, which is essentially that unless the child's safety and welfare require immediate removal, the court should always allow an unsuccessful party the opportunity to apply to the appellate court. Turning on to the issue of threshold and establishing causative link, we look at the case of Re EY, which concerned an appeal against a judge's decision finding that the threshold had not been met. E was a young person, 14 years old, and her older sister lived with the father and had occasional contact with the mother. There had been referrals made to the local authority over a number of years concerning the children being neglected. There were then further referrals, which included an allegation that a 15-year-old girl had been raped in the family home, although the allegation was later retracted, that the subject children shared a bed with an older male, had observed adults having sex in the home, had been permitted to spend time with their boyfriends. They were placed on the child protection plan, and thereafter, there were further referrals, although these were not substantiated. In November 2021, as alleged that E had been slapped, the older sister alleged that E, the 14-year-old, had been slapped by the father. There was an assessment which concluded that the children were not at risk of physical abuse. Yet more referrals followed, and some of these related to a number of sexualized comments made by E with specific reference to the father. He was subsequently arrested on suspicion of sexual activity with the child, and the children were accommodated by the local authorities. E was under a ICO, whereas S, due to her age, was under Section 20. A clinical psychologist, Dr. Timberlake, was instructed to provide a global family psychological assessment of the family. And he summarized his findings as follows. There were concerns regarding the father's management and regulations of his own emotions. E had been subjected to considerable harm whilst in the father's care. There would be considerable risk if E were to be placed back in the care of the father, given his lack of insight. E was experiencing mental health difficulties. She was identifying as a non-binary. But at the final hearing, the local authority did not seek to prove the sexual allegations made by E against the father. Instead, their case was that E had been exposed to inappropriate sexual behavior. The judge criticized the local authority for seeking to rely upon the pattern of sexual abuse allegations, but not actually seeking to prove the allegations. And the judge also criticized Dr. Timberlake for not having provided an alternative view depending on whether the contested facts were proven. So an either-or conclusion. The judge went on to make a number of findings, but he indicated that because these were historic, threshold was not made out, and the local authority appealed. The Court of Appeal noted that there was nothing inherently unfair in seeking to challenge expert evidence in closing submissions, though the law on this point is, however, not finally settled, and an appeal to the Supreme Court's awaited. And that was linked to the fact that Dr. Timberlake had not been required by any of the parties for cross-examination. He added, however, that whatever may be the obligations on the parties seeking to challenge the conclusions of an expert, the judge is not obliged to accept those conclusions. The judge is still to have regard to the relevance of each piece of evidence to other evidence and exercise an overview of the totality of the evidence in order to come to a conclusion. The Court of Appeal said that had the judge conducted the necessary overview of the totality of the evidence, there was reasonable prospect that he would have concluded that threshold had been met. Lord Justice Basic went on to say that the local authority were entitled to rely on historic matters regardless of whether or not they had taken action in respect of these in the past. And these historic matters, alongside the more recent matters, could be a factual basis to establish threshold. This is going back to looking at the totality of the evidence. Oh. Moving on to the case of Y, V, and B, a decision of Her Honor Judge Reardon. This was following a fact-find hearing in respect of injuries suffered by a 9-month-old child. There were actually 3 children, a 13-year-old, a 12-year-old, and B, who was the 9-year-old, the one who suffered injuries. The parents had been separated, but the girls remained with the mother. Father had contact with all 3, but his contact with B, the 9-month-old, was always in the mother's house. In June 2023, B was presented to the hospital with a series of very serious injuries, primarily fractures to her skull and ribs. The unchallenged view of the medical professionals was that the injuries had to have been sustained in at least 2 incidents. The local authority case was that the injuries were deliberately inflicted or through negligent handling, and that mother was the perpetrator. Mother's response was that she hadn't harmed B, she didn't know how the injuries were caused, And there was a possibility they might have been caused accidentally when she wasn't present. There were small windows when third parties were looking after. While the judge referred to the positive evidence of the mother's care of the children, she was also troubled by the mother's lack of curiosity as to how the injuries were caused, and she thought that the mother was holding back from giving a full and truthful account to the court. However, Judge Reardon was unable to find that the mother had caused the injuries, but did find that the mother knew how the injuries were caused and had chosen not to tell the truth. The Guardian appealed the decision and was supported by the local authority. The Court of Appeal reiterated that it is possible in cases of NAI for the attributability condition to be satisfied without identifying the person who inflicted the injury. But it is well established that the court should, where possible, endeavor to identify the perpetrator. Standard of proof is still the balance of probabilities. If a judge cannot identify a perpetrator or perpetrators, it is still important to identify the potential pool. More recent guidance as to how a judge should approach the task of identifying whether someone was in the pool of perpetrators was given by Peter Jackson in the case of Reed B. 2019. And the court commended the approach prescribed in that case, namely, you identify a list of possible perpetrators, including those named and unnamed. Consider whether the local authority has proved on a balance of probabilities that a person was the perpetrator. If not, identify those persons in the list in respect of whom there is a real possibility that they were perpetrators. The Court of Appeal went on to say that the court can make findings not sought by the local authority, provided that any additional or different findings made were securely founded in the evidence and that the fairness of the fact-finding process was not compromised. If the court forms the view that the evidence may support findings on a basis which had not been raised or considered during the hearing, it is incumbent upon the court to address that possibility if the potential findings are material to the welfare decisions which it is required to make about the decision. So essentially, the potential perpetrators should be put on notice and given the opportunity to cross-examine, make representations, etc. Drug testing. We have the recent case of Reed D, where the Court of Appeal allowed an appeal against the making of an interim care order. In July 2022, C, the child who was then age 4, was admitted to hospital, and subsequent blood tests confirmed a likely overdose of topiramate, a medication used to manage and treat epilepsy and migraine, and this had been prescribed, in fact, to her older sister A. Almost exactly a year later, she was once again admitted to hospital. Blood tests once again confirmed high levels of topiramate. Hair samples were then taken from each of the children in October 2023, which revealed that all of the children showed signs of passive exposure to topiramate, with likely ingestion in the case of C. There was then further testing done, and that indicated that the children had been passively exposed to a range of Class A drugs and cannabinoids throughout the testing period, so a period of a year from October 2022 to October 2023. There had been an order for hair strand testing of the mother, the maternal grandmother, and the uncle, but the maternal grandmother and the uncle refused to submit to hair strand testing. The mother did do so, and her test results were negative. The maternal grandmother and uncle attended a hearing with the court's permission and raised concerns that the children's positive hair strand tests were inaccurate. The local authorities subsequently proposed to move the children to foster placement. The Court of Appeal was critical of the hair strand test reports and the presentation of them by counsel to the circuit judge, so take heed. Mr. Justice Cobb set out a number of instances where the specific data findings within the reports were not fairly reflected within the general summary sections. And we're all familiar with this. You look at the breakdown of the actual findings, and it doesn't quite tie up with the overall summary set out. The Court of Appeal noted that if it was to be the local authority's case that the children's positive drug test was attributable to exposure to drugs used by their mother, that was not supported by her negative test results. The judge was criticized for having relied upon the position statements filed by the advocates, none of which had referred to the more detailed data findings in the children's hair strand test reports, because and particularly where these more detailed findings undermine the picture painted in the general summary sections. Local authority made no reference in their position statement to the negative drug testing of the mother, nor the request by an expert who'd been instructed jointly, who had requested that the children be tested further. And the position statement prepared on behalf of the Guardian had only referred in general terms to the children's recent positive drug test results, and explicitly asserted that the time span in which the positive results for exposure to drugs had been detected overlaps with the period where the children had been living with the maternal grandmother and uncle. And you'll recall that the local authorities' plan was to remove the children from them. In fact, by the time of the appeal, there had been further testing of the children. There was no evidence of Class A drugs detected in any of the samples provided by the children. Noting what appeared to be contradictory findings between at least two of the reports concerning the children, the court said that the signs of hair strand and nail testing for prescribed and non-prescribed drugs and alcohol has contributed to family decision-making for many years. It is still an evolving field, and as previous case laws caution, hair strand testing has its limitations. The variability of findings from hair strand testing does not call into question the underlying science, but emphasizes the need to treat the data with caution. There were three themes highlighted. Hair strand test results cannot be viewed in isolation. In fact, in better reports, we see that quite often. When scientific investigations such as hair strand tests are carried out, the expert must describe the process, the record of the results, explanation of their significance in a way which can be clearly understood by those who are going to rely on the information. So essentially by you and I who don't have medical degrees. The writer of the test of the report must make sure as far as possible that the true significance of the data is explained in a way which reduces the risk of it becoming lost in translation. Allowing the appeal and referring the hair strand test reports for the children, the Court of Appeal said that on closer analysis, the evidence was not, in my judgment, as stark or as disturbing as it had been presented to the judge or as she had understood it. The judge appeared to have treated the evidence from the hair strand test reports as determinative of the issue of exposure. The judge should instead have taken into account and recognized the inherent occasional anomalies in the hair science testing, particularly where the expert instructor had recommended further samples to be reviewed. There was a failure to consider the data deeper within each of the reports. The judge had not considered sufficiently the context of the broader picture, reminded herself that the test results were only part of the evidence, and the advocates had failed to draw the judge's attention to the yawning gaps in the evidence. It is difficult. We frequently get these test results in the morning of the hearing, 5 minutes before we walk into court, but caution should be taken in terms of how we interpret these results. And what the Court of Appeal said, that it was vital for the advocates to draw to the judge's attention what the science can and cannot tell you, carefully examine hair strand test reports in full, so far as thought to be helpful or appropriate to do so, and distill the highlighted three themes. assist the judge to consider the results in the context of the whole of the evidence, including the statements of those who are alleged to have exposed the children to the drugs identified, other evidence, for example, observation, which may or may not suggest drug use in the home, and the presentation of the children and the adults and the history of the family generally. Now, I'm sure most of you are familiar with the case, the West Northamptonshire case dealing with intermediaries. But by way of reminder, this is a case where the mother was profoundly deaf, and there was a cognitive assessment undertaken of her by a deaf specialist, Dr. O'Rourke. Dr. O'Rourke advised that while the mother did not have a learning disability, her functioning was at the low range level, and she would benefit from a deaf intermediary. The judge considered whether it was necessary and proportionate for the mother to be assisted by a deaf intermediary, as well as suitable deaf interpreter. So, was it necessary to have a full panoply of support? And Dr. O'Rourke advised that a hearing intermediary was not only no substitute for a deaf intermediary, but there was a potential for hearing intermediaries to report in respect of a deaf parent misleading the court. Essentially, that there were nuances that people who sign language on a regular basis would have and would not be picked up by someone who did not have that disability. 11J took the opportunity to set up some of the guidance for use of intermediaries in the family court. She noted that the position in respect of the appointment, qualification, duties of intermediaries in family justice systems not clearly set out in the FPR or any practice direction, but is contained in Criminal Practice Directions 2015. The guidance set out in the case of Queen and Thomas, a 2020 case, a criminal case, is directly applicable to the family court, and the following principles can be extracted. Exceptionally rare for an order for an intermediary to be appointed for a whole trial. They are not to be appointed on a just-in-case basis. The judge must give careful consideration not merely to the circumstances of the individual, but also the facts and issues in the case. Intermediaries should only be appointed if there are compelling reasons to do so, not just because the process would be improved. In determining whether to appoint an intermediary, judge must have regard to whether there are other adaptations, other special measures which will sufficiently meet the needs of the person to enable effective participation. If every effort has been made to identify an intermediary but none found, it would be very unusual for the case to be adjourned for lack of intermediary. And in those circumstances, adaptations will need to be made. The court reminded us that all advocates in cases involving vulnerable witnesses or parties should be familiar with the advocate's gateway and the advice on how to help vulnerable parties understand and participate in the proceedings. It's actually an extremely helpful website, and reminded us of the words of Halit LJ in the case of R and Lubemba. Advocates must adapt to the witness, not the other way around. There is another case of X and Y, also a 2024 case, EWHC 906, and that gives similar guidance on the issue of intermediaries. Move on to the rather distressing case of X and Y, revocation of adoption orders. This was an application made by the adoptive mother to revoke adoption orders made in respect of two children who were by then aged 16 and 17. They'd been placed in her care when they were just 4 and 5 years old. By August 2021, the children had left the adoptive mother's care. They were initially living with a maternal aunt, and then went to live with the mother. There was a parenting assessment which recommended that they remained in the care of the biological mother. And one of the children, unfortunately, made allegations of physical and emotional abuse against the adoptive mother. The application for revocation was supported by both the children. And the issue before the court was whether the court had the power to revoke the adoption orders, and if so, whether that power should be exercised. The adoptive mother sought to argue that the High Court could use its inherent jurisdiction to revoke the orders, or in the alternative, that there's power to revoke under the Matrimonial and Family Proceedings Act. The court said that the only statutory ground for revocation of an adoption order is under Section 55 of the Adoption and Children Act, which did not apply in this case. She noted that under Section 29 of the Children Act, a person who had parental responsibility for a child cannot simply surrender or transfer any part of that PR, and commented that an ability to revoke an adoption order on welfare grounds would put an adoptive parent in a different legal position to a birth parent. She went on to say that the authorities show that the court can only set aside an adoption order in highly exceptional and very particular circumstances, and the only ground for setting aside is substantial miscarriage of justice. Some of the authorities in the High Court were reviewed. Those authorities appeared to extend the ground for revocation beyond the fundamental breach of natural justice. But essentially, what the Court of Appeal went on to say was that the inherent jurisdiction cannot be used simply to reverse the outcome under a statutory scheme which deals with the very situation in issue on the basis that the court disagrees with the statutory outcome. There are cases where the power to revoke or set aside under the inherent jurisdiction exists, but that is essentially under fundamental procedural irregularity. Unfortunately, this case did not fall within that category. This application was made on welfare grounds. And the court took the view that to use the inherent jurisdiction in these circumstances would cut across the statutory scheme in a way which was not permissible. It was therefore not possible to revoke the adoption orders. However, the court did grant the application made on behalf of the children to change their surnames back to that of the biological mother. And that's it. Thank you very much.